Now we consider the Sixth Amendment. The Sixth Amendment right to counsel also can result in the exclusion of evidence. We'll see other Sixth Amendment issues below in non-exclusionary rule contexts. But for our purposes here, we're focusing on the Sixth Amendment as a justification for excluding otherwise probative evidence against a criminal defendant. Remember, up front, one detail with regard to the right to counsel is a criminal defendant has the right to serve as his or her own attorney, even though a publicly appointed attorney or a privately hired attorney might well do a more effective job. And we know that the judge in a criminal case has to admonish a defendant who wishes to represent himself or herself. But ultimately, we have to defer to a criminal defendant who chooses to be his or her own lawyer. So, the Sixth Amendment requires the right to counsel, but it also affords each of us the right to serve as our own attorney. Remember that the right to counsel attaches after judicial proceedings begin. That's the national rule. There are some variations in state law, which we'll get to in a moment. But generally speaking, there's no right to counsel until a case has been filed against a criminal suspect. Probably the most important issue and the most commonly tested issue in the Sixth Amendment is intrinsically related to the law of evidence. And we'll see it in evidence as well when we get to that topic. The Sixth Amendment grants each of us the right to confront adverse witnesses. And this is very straightforward and simple, and I'm not going to complicate it for you here. But the most common way in which the confrontation clause or the confrontation right is tested is where we've got two defendants who are on trial together. Joint defendants facing possible criminal liability in one trial. Well, suppose part of the evidence against each defendant is statements made by the other defendant. Well, each defendant has a right to confront the statements made by the other defendant. In a joint trial, this may be impossible. And if it's impossible, those statements will have to be excluded. That's one reason why, not uncommonly, more than one defendant being tried at the same time will have separate juries for each defendant, so the juries don't end up hearing exactly the same evidence. Now, it's far more common for criminal defendants to be tried together in front of one jury, and that's why this issue comes up as regularly as it does. Now, one idea with regard to the right to confront, which is, again, very commonly tested, is a situation where, at trial, a witness is unavailable, and that witness has testified previously. And the question presented is, does the fact that the lawyer cannot cross-examine this person at trial mean that the prior testimony doesn't come in? And the structure for analyzing the issue is this. Has the testimony that we are seeking, the prosecution is seeking to enter, been properly subject to cross-examination before by somebody with the same motivation to cross-examine as would be the case in the instant trial? To the extent that the motivation for cross-examination was substantially similar or even identical, under those facts, it's much more likely that the prior testimony will come in. To the extent that the motivations for questioning are different, the Sixth Amendment right to confront very well could prevent that prior testimony from coming in here. Another area where the right to counsel comes up quite frequently is with regard to lineups and other pretrial identifications. Remember, right up front I indicated that the right to counsel typically does not attach until a criminal case has been filed against a defendant. But many states do afford suspects the right to counsel when they are subject to pre-indictment lineups. That's another area where local state law may differ from the federal protections. But by and large, a pre-indictment lineup is one in which the right to counsel does not attach. We'll use a due process standard for admissibility, and whenever we can show, we on the defense, can show that there has been some violation of the right to counsel with regard to an identification. Under those circumstances, the proper remedy is to exclude the identification. And that's about as simple as an analysis of the Sixth Amendment for exclusion can be done. Again, I recommend do a high volume of practice. And in our hypotheticals, I'll show you a fair amount of work on these issues. To the extent you don't fully understand them, make sure that you do. But again, remember that there are plenty of issues on the bar exam that are more important than this one. Before we move on, the next series of videos, actually the next video, will deal with non-exclusionary rule issues in criminal procedure. But before we turn to those issues, there are a couple of details that I want to bring to your attention about the exclusionary rule itself. Remember that the basic idea of the exclusionary rule, regardless of whether the defendant's justification for exclusion arises from the Fourth, Fifth, or Sixth Amendments, is that illegally seized evidence will be deemed inadmissible, and any fruit of that poisonous tree also will be inadmissible. So let's back off for a couple of steps and think about the law of evidence. We'll touch on evidence in great depth when we get to that seminar. But for our purposes here in criminal procedure, think about this. For any item of evidence, in criminal or civil court, the person that wants to present the evidence has to show that it is logically relevant to a fact in dispute. Furthermore, the person offering the evidence has to show that it is legally relevant. And that's true of a prosecutor in criminal court in exactly the same way that it's true of a civil plaintiff in civil court. And both in civil court and in criminal court, a defense lawyer, can object to the relevance of an item of evidence, and that's true in criminal cases as well. But then, once we are finished with the relevance issues in criminal procedure and in criminal law, we focus on the crim pro justifications for exclusion, the Fourth, Fifth, and Sixth Amendments. But we will also see in the law of evidence that all of the other rules of evidence, like, for example, hearsay, apply as well. So this is one of those instances in which the law really is that sort of seamless web. But one final note, with regard to this idea of fruit of the poisonous tree, remember that that evidence can find its way into court through a different avenue. If there is some independent source that's prepared to offer the same testimony, untainted by a constitutional violation, it'll come in. Suppose in between the illegal act and the fruit of the allegedly illegal search, suppose the defendant does something that is an intervening act. Again, that's a fact that could render admissible evidence that otherwise would be inadmissible. And then, finally, another comparatively recent development in the law of criminal procedure, where law enforcement illegally obtains evidence that it inevitably would have discovered otherwise. Well, under those circumstances, the criminal defendant will have to deal with the evidence, because if it were inevitably to be discovered, we're not going to exclude it merely because law enforcement violated some technical provision of the Bill of Rights. So that wraps up about as concise a discussion as you can hope for the law dealing with the Fourth, Fifth, and Sixth Amendments. In our last substantive video for the law of criminal procedure, we'll go over all of the non-exclusionary rule issues, and then we'll turn our attention to the 6 hypotheticals.